Hello, everyone. Rilus Law here, getting the stream set up. Live, all the places. Should be live Instagram as well, too. All right, great. Looks like we got it going. So today, the question we're talking about is, when is the best time to negotiate with creditors? Now, theoretically, if you can negotiate after you're dead, wouldn't that be the best time? I'm saying yes, it is. So in today's discussion, what I want to talk about is how debt is dealt with in probate and also trust administration. So let me share my screen here. So hello to everyone watching live and watching on the replay. Thanks for tuning in. If you have any comments or questions, make sure to leave them if you're watching live or from the future. Thanks for tuning in. So going to be doing more videos this year. Let me know the topics that you'd like to hear about. So here's my little AI guy. I used AI to create the image, the thumbnail for this. All right, I'm Rilus Law. I practice law, Arizona and California, estate planning, probate, over 15 years in this area. Even more than that if you count from when I was in college. So first, let's talk about estate. So what is an estate? So in order to understand debt, how it works in probate and in trust, we need to define the terms. So estate refers to everything a person owns, whether alive or dead. So this guy, our friend Mr. Estate, he's got a bank account, a house, an IRA, life insurance while he's alive. That's part of his estate. He passes away. Those things are in his name still, so still part of his estate. Now, estates are controlled by a last will and testament. So last will and testament is the document that designates where the estate goes, but to activate the will, probate is required. So a trust is a legal document where you name the successor trustee. What's up, Sandy? Watching on the Instagram. Thanks for tuning in. A trust is a legal document where you designate who's going to be in charge after you're gone. So the person that creates a trust is called the trustor. I use the briefcase. It's the boss. The trustee is the manager, and the beneficiary is the one that benefits. So a way a trust avoids probate is because the assets are inside of the trust. If you have your house and bank accounts owned by the trust, after you're gone, they're still owned by the trust. So the trust gets locked at that point, or it's revocable, but a trustee steps in to manage those assets inside of the trust. So to be controlled by the trust, the assets have to be titled in the name of the trust. Okay, we went over that. So that's how a trust avoids probate. So probate, I practice Arizona and California. I don't do probates in California. So Arizona, we can do what's called an informal probate where the court supervises, but we don't actually have to go into court. Formal probate, this is how they do it in California all the time. And in Arizona, we only have to do formal probate if there's some sort of issue. But formal is where you have to go into court before the personal representative is appointed. There has to be a hearing before they're appointed. All right, so how long is probate and what does that process look like? So once we get hired to do the probate, it takes us about 2 to 3 weeks to do the application. And then we send it into court, and depending on the county and all the circumstances, it takes them about 2 to 6 weeks to approve everything and appoint the personal representative. Now, after that personal representative is appointed, they have to publish in the newspaper to start a 4-month creditor period. So that's a requirement for probate. Even if there's no creditors, you always have to publish in the newspaper to give any potential creditors a chance to make a claim against the estate. And if there's creditors that you know about, you're required to give them notice. So that's required in probates. And after you give notice, you can collect the assets, wait for that creditor period to end to see what debts there are, and collect all the assets, see what debts are valid, and then you can negotiate with those. So in probate, you have to give notice, you have to satisfy all the creditors, but that doesn't mean that you can't negotiate with them. Now, the reason I'm doing this video is, we're helping one of our clients negotiate with the creditors. This is something that a lot of people don't realize that is possible. And I was thinking about the other day, what better time to negotiate than when after you're dead? And as I was preparing for this, I was talking to my paralegal, Lori. She does the probate and trust administration. And we're talking about how a lot of families, they want to satisfy, to pay the bills, to leave their legacy. And I was saying how I hope my trustee knows that I want to pay as little debt as possible. So after I'm gone, I no longer care about my credit. And that's why it's such an advantage to negotiate after the person's dead. Now, while you're alive, we care about our credit because that affects, kind of everything we do in our country. If you want to buy a house or a car and you want to borrow some money, you're going to be affected by creditors. Like credit card debt. So I'm going to be talking about credit card debt in a minute here, real space investments. So we're going to be talking about secured versus unsecured debt here in just a second. Okay, so that's kind of what probate looks like. The main thing I want to talk about is that you do have to give notice to creditors. You do have to satisfy the creditors, but it's a great chance to negotiate with them. So if you're doing a probate, make sure your attorney is doing this on your behalf. This is something I've seen. I've seen attorneys and fiduciaries charge huge fees, and they don't do anything to negotiate down the debt. All right, so after someone's gone, we need to determine how the assets are owned. So it's important to determine whether they're in the trust and controlled by the trust, if they're in the name of the deceased, therefore controlled by their will if they have one, or if there's a beneficiary listed. So for things in the estate, they're controlled by the will, or if there's no will, we have the laws of intestacy. Okay, so let's talk about the difference between how debt is treated in probate versus trust administration. And let me skip ahead to the real space investments. What's a newspaper? I love that comment on Instagram. I know, right? What is a newspaper? I don't know, but we publish in them for probate to satisfy the requirement. Now, another good thing about hiring an attorney to do the probate is we publish in the cheapest one that satisfies the requirement. And the creditors know about it. They're looking in that area. So let's talk about secured debt versus unsecured debt. So this is one of my favorite images for an IOU. Who knows the movie? If you know it, leave it in the comments. Easy one. But when you borrow money, it's basically an IOU. This example is showing a deed to a house. Now, a house is usually secured by the mortgage. So the bank, there's paperwork in place saying that if a person doesn't pay the mortgage, the bank can take the house back. So the bank or the house is the underlying security. So this is a secured debt. Cars are usually secured debt as well. So on a car loan, if a person doesn't pay their car loan, the bank can take the car back itself. Now, credit cards would be an example of unsecured debt. So credit cards are not secured by anything, so unsecured debt. So there's opportunity there to negotiate with the unsecured debt. Okay, so I described the probate process, what it looks like for the will or the probate process. We've got to give notice to the creditors. Now, in a trust, it's the trustee's job to distribute the assets in the trust to the beneficiaries. The trustee does not necessarily care about the debt. Now, a good trust, let's get through this. Already went through all that. So I asked AI to give me a graphic that talked about may versus shall. Now, in my trust, it says that the successor trustee, they may pay for expenses. So they can use assets inside of the trust to pay for things like the funeral and expenses in the estate. So let's say there's money in here in the trust and the person had some debt in their name individually. So if it was unsecured debt, like credit cards, and all the assets are in the trust and we're not doing a probate at all, we can tell the creditors that there is no assets in the estate. So nothing's left in the name of the deceased individual. So therefore, everything's in the trust and nothing stays in the name of the estate. It all transfers. So that's another reason why probate, or why it's another reason why trusts are such a good idea. By avoiding probate, it also puts the representative of your estate, if it's a trustee managing things, they're in a good position to not have to pay or negotiate with unsecured debt. So that's the main thing today. Just wanted to let you know that if you are administering an estate, there are some nuances there. You got to be careful. Be really clear how things are owned. Are they owned by the trust or are they owned by an estate? I'm Rilus Dana here, Rilus Law, Arizona, California. Need any help with your estate planning? You can reach out to me. Thank you.